is Sharanya and I'm from Shipping Management and DSM5. So in the application today I'm going to discuss about is my topic about dangerous good, which is in the safety. So today I'm going to discuss about the one of the most critical applications in the maritime law, which is the implied obligations relating to the dangerous good in the carriage of goods by sea. So the carriage of the good by sea is governed by a complex framework of application developed through the centuries of maritime practice. So among these of the duties of relating the dangerous goods of stands by the most critical, given for the profound implication by the safety of sea, like environmental protections, and then the commercial interest of all the parties of involved. Now, who bears the obligations? So the primary responsible reside with the shipper. So the party who deliver the cargo, like carries the transportations, the shipper is typically identified in the bill of lading or charter by as consignees of the goods. These varies of depending of the type of the charter involve of charter parties. The charter typically act as a shipper and bears of obligations. So in time, charter parties may fall either the charter who direct the vessel employment or one of the actual shipper of the goods, and depending on the contractual agreement. So what makes these obligations particularly signify in this absolute and the strict nature? This is mean of the shipper cannot escape liability of demonstration. They act with reasonable care, or were simple unaware of the dangerous characteristic. And why? Because the dangerous goods poses of expenseless risk of the vessels, crews, other cargo. So what is specific applications? Specific application like dangerous goods applications encompass like 4 interconnected duties. So first is shipper must not ship the dangerous goods without the private notice to the ship owner. So these will disclosure requirement enable to ship owners to make an informed decision about the whether to accept the cargo or whether it's precautions to implement. Second, if dangerous goods are shipped, the shipper must provide full and accurate information. These include the specific characteristic that makes the goods like hazardous, accurate, proper procedure, so emergency responsible measure, and then regulatory classifications under the international conventions as the MIDG code. So where does these applications came from? So now the dangerous goods application derived from the multiple legal sources, reflecting it fundamental importance. At the common law, the obligation has been recognized since the 19th centuries. So the principal law is established in the landmark cases like Brace versus the mainland in 1856, and has the consistent refined though the subsequent due diligence decisions. So in charter parties, it exists is an implied terms in both voyage and the time charters. Even the contract is silent. So the modern form of NYPE and BIMCO often include the express clauses supplement of the common law position. So that the DG code is aborted under the SOLAS, like provide the regulatory framework for the classification, packaging, labeling, and document. So the national legal system is the most maritime nations, like the UK Carriage of the Goods by CAC 1971, like give this international standard statutory force. And furthermore, now is going to talk about the case law, which is the Garnish NK, which is, let me illustrate with the two landmark cases. Like first is the Garnish NK is the leading modern authorities of the obligations. So the fact the vessels is Garnish NK was chartered to carry government pallet from the Dakar, Senegal. So unknown to the ship owners, and then the cargo was invested with copra beetles. So the pest highly dangerous to the agriculture. When they arrived in the Dominican Republic, so the authorities refused to allow discharge, and then the order to the vessel to leave the country. So the vessel is include the subsequent causes, and then seeking the alternative ports before eventually having to dump the cargo of the ship. So the legal issues of Janik Henke cases. So was the cargo infested with beetles actually is a dangerous good? The charters argue the danger of the merely regulatory, not physically, to the vessels. So the judgment, the House of Lords helped the cargo was included in need the dangerous goods, and then the lot of rods established the critical principle. Goods are the dangerous not only when they pose physically danger, but also when they are dangerous in the law. So merely they expose the vessels to detention, confiscations, and penalty. Here I'm going to discuss about the case 2, which is the World Navigator from my research. So the second key case is the World Navigator, right? So which laws which address the cargo that becomes the dangerous. So the vessels carry bag of sugar from Cuba to Morocco. So during the voyage, so the water entered to the hold due to the rough weather and the possibly vessel defect, and then the sugar become hydroscopic, and then it absorbs the moisture and become wet, and then heated, and then the fermented, like that situations, and then this generate carbon dioxide and carbon monoxide gas, which is harm to us, okay, and creating serious explosions and toxic atmosphere risk. So the master had to jettrisons cargo to prevent the disaster. So the legal issue is the charter argue probably packaged sugar isn't dangerous. So it's only become so because the water entered in the package, the hull, so which has the ship owner responsibility to prevent the throw proper seaworthiness. So the judgment also, the court had, while the ship owners may have the branches, so some ship owners branches seaworthiness by allowing water entry. This did not absolve the shipper. So the shipper had a duty to warn that sugar become dangerous when they expose to the moisture, and to ensure the packaging would be prevent during the ordinary workage incident. Furthermore, in this topic is why is obligation is so important. So obligation is very important because the obligation serve three critical functions in maritime commerce. So safety is the first and foremost safety. Vessel operates in challenge like in challenging environment where the fires, explosion, and the toxic release can be catastrophic, and then these strict obligations ensure to ship owners receive the informations needed to protect the crew lives, implement the proper voltage plans, and then select the appropriate firefighting equipment, and then prepare emergency response. And then historical incident proof this necessary. The 1947 Texas City disaster shows how improper declare ammonium nitrates could cause a massive destructions. In 2012, MSC Flaminia fire is containers carries dangerous goods, result in fatalities and total cargo losses. So in 2020, Beirut explosions, which is illustrates the catastrophic portions of dangerous material, and then these tragedies underscore why strict liability and comprehensive disclosure are external. So in this categorized, I would talk about like trade facilitations. So second, applications facilities in efficiency international trades. So it's great certainty in risk allocations. Ship owners can price service appropriately, like shippers can understand their duties. There's framework unable to save. So this efficient transport of ligamentations shipped like dangerous goods, and then that the exceptional modern industry while protecting against the unclosed hazards is the third thing that I would talk about this in this. After this, I would talk about like risk allocations, which is the third. It will be represent the economical efficient risk allocation. The shipper who manufacture or handle the goods pre-shipments are the best position. So to know that cargo is characteristic, they have to access to the technical information, safety, and then the data, safety of the data sheet, and then the cargo history. Conclusion, the dangerous goods application simplify how maritime law balance their commercial efficiency with the paramount of safety concerns. And that's all from me, guys, and thank you for all of your attentions, and bye.